Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
Superpowers and your power of attorney. Learn all about it on this episode of Helping Seniors as board-certified elder law attorney Bill Johnson guests with Helping Seniors TV host Joe Steckler.
Welcome to this edition of Helping Seniors. It's my very, very great pleasure today to have Bill Johnson. Bill is an elder law attorney, and probably, if we go back, Bill, to about 1997, we've been doing radio and television all those years, and I will freely admit that every time I've done a television or radio show with you, I've learned something.
Oh, well, that's good. That's what it's all about.
Exactly right. It's information and education. And though I've been doing this and writing articles on this and doing all this stuff all these years, for almost 29 years, there's always something to be learned.
Yes.
And I think one of the greatest failings, misgivings, whatever kind of adjective you want to use to describe it, is that the general American public still does not recognize the importance of good legal advice.
I would agree to that to some extent. They usually don't plan. Usually it's some sort of crisis that brings everything to the head.
Yep. I can remember years ago, Terry and I were called, my wife, Terry, we were called to a hospital, and we went to the room of the person. And this guy was a Naval Academy graduate, a retired Air Force officer, and he did not have a durable power of attorney. I was appalled. And then we got a hold of his wife, quickly got a hold of her attorney. I think we called you, and in fact, we did call you. And the durable power of attorney was able to be put in place. And that's one of the things we're going to talk about today, because we're going to talk about the durable power of attorney, but there's a new thing, and I'm not going to talk about it till Bill is ready to talk about it. And because I won't say what I've done to him, because he's kept information from me, information that I think is extremely important. As Bill discusses it, so will you. But first, Bill, what is a durable power of attorney, and why is it so important?
Well, a durable power of attorney is a document that is a grant of authority to whoever you name, usually called your agent. And in that document, you grant the power or delegate powers to that person so that they can manage either your finances, your health care, or both. So the reason it's called durable means that if you become incapacitated later, that document still continues on so that they can use those powers to manage your finances and health care in the event that you do become incapacitated.
Okay, but you mentioned what happens in circumstance. But what happens when people don't go to an attorney to do a durable power of attorney, and they go to a store that sells stationery and gets a pre-printed durable power of attorney form, and they exist?
Correct.
Tell our viewing audience why the two of us, and you in particular, why do you recommend that they not do that?
Okay, well, I get these in my office all the time. They're usually like a one-page durable power of attorney that they've gone and got from a office supply store, and that they've executed, and a lot of them just simply say, I grant all my powers to so-and-so, their agent. Well, in Florida, unless you specifically give somebody a power, they don't have it. Okay? And so this general broad grant of authority to someone doesn't work because it's not specific. So you have to say, I give somebody the power to do all my banking transactions, or I give somebody the power to sign a deed, do a closing, mortgage a property, transfer a property. You have to go into very much detail on each and everything that you want to grant. Also in 2011, we had a law change, and we constantly are getting and still getting powers of attorney that were executed after 2011. So the new law applied, but they didn't have any of the language that the new law required, and they didn't have the what we call superpowers, such that they would have to be signed off on. So a lot of times, people were getting forms that were severely outdated. You know, once they go into the office supply store, they can sit there on the shelf for years, and you may not be getting the latest, greatest version.
Okay, let me ask you a two-part question. There are many different types of powers of attorney. Other than a durable power of attorney, do any of these other powers of attorney go on after a person dies, and are they effective after a person dies? And go ahead, answer that part
Powers
first.
of attorney cease to function after a person dies.
Okay,
Okay, so they're cut off at that point, or if they're revoked or they terminate for some other reason. There are a variety of reasons, but after somebody dies, that's when your executor takes over. So the power of attorney does not apply after death. It gets canceled. The difference between a durable power of attorney and other power of attorneys is that a durable power of attorney continues on after somebody's incapacitated, where under the law, a regular power of attorney that's not durable ceases or gets suspended. So, and to be durable in a durable power of attorney, it must say that this document survives the mental or physical incapacity of the maker. So there must be some sort of paragraph
okay.
in there. It's not enough just to say durable power of attorney and assume everybody knows that.
Okay.
And I have found documents that say durable power of attorney, but do not contain that paragraph. So
So
they
the
weren't
language of the law has to be there.
correct.
Now, I remember what the other part, my two-part question was. You made a comment that people come in with one page. A good durable power of attorney probably will contain about 20 of these pages.
Correct. Usually they're somewhere on the order of 15 to 20 pages if they're done by an attorney, because what we do in there is we grant all these powers that we can think of to somebody because they may need that, you know, to sign your tax returns, admit you into a long-term care facility, to get into your IRA or 401k, to get at cash value in life insurance, maybe to change beneficiaries, maybe to create a trust to qualify for Medicaid. And we have to put all of that in that power of attorney.
It has to be spelled out.
Correct.
Right. Now, once you do a power of attorney, a durable power of attorney, when you used the word earlier on execute, what do you mean when you say execute a power of attorney?
A power of attorney must be signed in the presence of two witnesses and a notary. So you have to execute it, sign it, and then you have to have two witnesses and a notary, because that technically that's a formality after 2011. Prior to 2011, it could just have two witnesses, but they've kind of cleaned things up in 2011. So you're supposed to have two witnesses and a notary. Now, if you lived in another state that did not require that, and you moved to Florida, Florida will recognize the power of attorney as long as it was properly executed in the state where you came from.
So they'll still recognize it
Yes.
even after 2011?
Yes.
So that's another reason, you know, you and I have done so many shows, television and radio, that we see continually are a continuous act of people to not do what they should do to protect themselves, their families, their possessions. I can imagine what it must feel like to have a $500,000 estate and go in and have somebody take that estate away from you that you didn't want to have them have that money.
Well, let's talk about that, because it's a durable power of attorney is the best document in the world. It's also the worst document in the world. By best, I mean it allows your agent to go do anything they need to do with your finances and sometimes healthcare, depending on how it's written. Now, if, say example, you're married and your spouse has a big 401k, and all of a sudden they have a stroke and they need money to pay for caregivers. Now, if you haven't gotten a power of attorney from them and you try to get in their 401k, guess what? You're not. And then you're going to have to go to court and do a guardianship, which can be a very expensive, invasive, and time-consuming procedure. So there are powers that we need to give people. I get this all the time. People come in my office, they're married, and say, well, all our accounts are joint. Why do I need to have a power of attorney? Well, not everything's joint. IRAs, 401ks aren't jointly owned. Also, what if you have to sell a joint asset? Say you wanted to sell your house and downsize, but nobody, your spouse had a stroke and can't sign and is incapacitated. Well, where are you going to get the authority to sign their name? So it's one of the best documents in the world, but at the same time, it's one of the worst.
How could it be bad?
Well, you've got to have an agent, that's the person you name in the document, that you trust.
Yeah.
Because it can be a license to steal. And, that same authority you gave somebody to go into your IRA and take out money to pay for your care also gives them the authority to go in your IRA, take out your money and run with it. So it can be the best document in the world. It can also be one of the worst.
Let's say that happened. A family, as far what I know about the law, if that should happen, the smartest thing that the person could do would be to get a hold of an attorney like you as quickly as possible. But even as quickly as they could get to you, if the person withdrew that money, how long do you think it would get to be for you to put an emergency guardianship in place?
Well, that's a great lead in to something that's brand new, Joe.
Are you going to talk about the superpowers?
As of July 1st, no, I'm not going to talk about the superpowers yet.
Okay, all right.
As of July 1st in Florida, you can now go get an injunction against exploitation. Just like you could get a domestic violence injunction, your guardian, your agent can go to court and get an injunction against exploitation that will freeze all your accounts, bar the exploiter from contacting you. If they're living with you, they can be removed from the house. And this all can be done very, very quickly. So you don't even have to wait now for a guardianship hearing to get a emergency temporary guardianship. There is a quick way to stop the exploitation while you are getting the guardianship. And that's brand new as of July 1st.
Okay. But having said that, what else could a family member do? Let's say, let's think about a situation that you've got the wrong person managing your trust, and they're taking money out for purportedly one reason, but using it for something else,
right?
To line their own pockets. And is there any kind of a vehicle in place, or how do other family members monitor the depletion of the estate?
Well, that gets tricky because it depends on who that trustee has to account to. Now, if they have to account to you, you can obviously demand an accounting of where everything's going. If it's your trust and somebody's managing it for you, you certainly have that right to an accounting of what's going on. It gets a little trickier if the trustee is managing the trust on behalf of some individuals that may or may not be entitled to an accounting. And then you would have to go back and remove the trustee if you found some improprieties.
The power, the law that just went into effect, does that enable a family to do what we're talking about? Or will we
Well,
go
it
back to
would
what?
stop the exploitation. So
Okay.
if it was your trust and somebody went in and they were taking your money, you certainly could go into court. Your guardian, if you had one, could go into court. Somebody who's going to be your guardian or who has applied to be your guardian could go into court and get this injunction.
Well, let's go back to what happened in 2011 with the Superpowers Act.
Okay.
All right, because there are 5 different parts to that, and one, I think, isn't there a part of the superpower things that would let you set aside that trust?
Well, correct. There is. In a power of attorney now in Florida, there are certain types of clauses that the person not only has to sign at the end of the power of attorney document, but they have to initial or sign next to these clauses for somebody to have that power. Those powers, just to give you a taste of what they are like to create a trust, to change a beneficiary, to revoke or amend a trust. So those kinds of things. So some of the bigger powers that you may or may not want to give somebody. The power to gift is another example. So those types of powers, you have to initial or sign next to them. So we're now getting power of attorneys that have these clauses that require signatures or initials, and we're finding a lot of people aren't signing or initialing them. And I'm not quite sure. I wasn't there when they signed the document, why they didn't. But if you haven't signed that, and for example, I have to do a qualified income trust to get you eligible for Medicaid, but you haven't given the power to create a trust, I'm kind of stuck. And if you've lost capacity, I'm going to have to do a guardianship to get that power.
So that makes it even more important that when people sign these documents, that they sign those superpowers.
Well, at least they know either what they're signing or what they're giving up.
I can't imagine anybody giving up the right for a family member to be protected under that type of a law, though, Bill.
Well, typically a lot of those powers come up in situations where we're doing long-term care planning with Medicaid, and a lot of those powers directly, if you were on Medicaid and I was your spouse, the last thing I would want to do is leave you as the beneficiary of my IRA. Because as soon as I die, if I died first, you would get all that money and be knocked out of the program, and then we'd have to reapply again. So,
what do you mean be knocked out of the program?
Well, you would be over the asset limit.
Oh,
so when I have two
okay.
spouses and one of them's on Medicaid, a lot of times we have to change the spouse who's not in the nursing facility, change their estate planning. So they leave their assets to the kids. But if they're incompetent, which sometimes they are, they may have dementia or something like that, we need somebody with the power to go change those beneficiaries. And again, that's a superpower. And if they haven't given that to us, then we're back to going to guardianship court.
Every time we talk about this, it seems like something else pops up that says one of the dumbest things I could do in planning my estate would not be to go to somebody that knows what they should be doing.
Correct.
And that's kind of a double-worded thing.
Well, in this day and age, everybody's looking for faster, easier, cheaper. So a lot of people are now resorting to doing online forms. They're not consulting with people who are regularly in the field. And so, I get wills that people have done online, and I come in and they've signed the will, but they didn't have any witnesses. And for some reason, they think that's a valid will. So there are a lot of ways you can screw up everything if you don't
Would that be
do it
invalid?
right.
If they don't have a witness, is it invalidated?
It's invalidated, yes. It's not, and they think they're covered because they printed something off the internet, signed it, or a lot of times what I see is they'll sign it and then the witnesses will sign it 2 days later, whenever their neighbors got home. That's invalid as well.
There was one other thing here. You mentioned the word compensation. How does that enter into this?
Well, there are ways that you can be compensated for serving as somebody's power of attorney. The statute does provide that certain qualified agents can receive compensation. That would be your spouse, a family member, a trust company at a bank, an attorney, a CPA. Those are some examples of people who can be paid to do the job of agent. So there are ways that people can be compensated for serving as your power of attorney.
If somebody was compensated for being managing your power of attorney, could that in some way be used to help them qualify for Medicaid? Could that be one of the costs written off?
You could, yes. That could be a part of the spend down or doing that. Now, the interesting thing is that there's a whole class of people who were left out of that statute for being compensated. And those are geriatric care managers, who in fact do lots of bill paying for people, but were left out of the statute.
Why don't they try and change that?
They probably will at some point, but right now, geriatric care managers are not a licensed profession in Florida. So anybody can go out and call themselves, quote unquote, a geriatric care manager. There is no formal licensure for that.
Yeah. We mentioned the word superpowers, and when Bill told me what he wanted to do on a TV show today, and he mentioned a word called superpowers, I went in on the internet and I Googled, I wanted to see what that really meant. And it talks about, I'm going to read these things, and the power to create an inter vivos trust. What does that mean?
Inter vivos means living, to create a living trust, a trust that you create during your lifetime.
Holy smokes. The power to amend, modify, revoke, or terminate a trust created by the principal.
Yep. So that would be any trust that you had created.
So if they didn't sign or initial that thing in the power of attorney, that specific thing, then this would no longer apply.
That is true.
So I'm thinking of a person that whether I should initial or not initial something like that. When they talk about power to amend, modify, revoke, or terminate a trust created by the principal, people, when they do a trust, they sit down with you and they try to really figure out what they want to go to certain people, certain places.
Correct.
Now, my criminal part of my mind thinks that I could use that to my own advantage if I got somebody to initial that, and if I wanted to get an attorney, they're going to amend that trust to where.
Well, that's a great point, because when you act as somebody's agent, you are bound by a fiduciary obligation to the person who created that power of attorney.
What does that mean?
What does that mean? Well, you have to act in their best interests, and you should act avoiding all conflicts of interest. And in the power of attorney statute, there is actually a cause for where you can go to court and get a judicial review of the actions of an agent if you believe they've entered into a conflict of interest transaction. And that can be done by the heirs or whoever is the people affected by the outcome of that. So you can go to court and request a judge review the actions of a power of attorney. There is a separate cause of action for that.
I'll bet you, Bill, that you could take and make a whole presentation out of those 5 things listed under the superpowers.
You probably could.
Yeah, because the other thing I didn't even mention, the power to create or change rights of survivorship and the power to create or change beneficiary designation. That last thing to me is extremely important when we talk about power to create or change a beneficiary.
Correct. And that could be abused, or it could be, like in my Medicaid example, a very positive benefit.
So it all goes back to how important it is for you to get a couple things. An attorney that understands what the heck he or she is doing,
Right.
and it can lead you in the right direction so that you understand the importance of getting somebody to do these things the way you want to have them done.
And let's just use some real life examples. If you had a trust and you had $2 million in the trust, you had long-term care insurance, you're probably never going to need Medicaid, okay? And with that, you may not want to initial those paragraphs in your power of attorney, because you may not want somebody going in and fiddling around with everything. Whereas if you have maybe $200,000 in the bank and you really need to protect that for a surviving spouse, and you may have to do some things and move assets around to qualify for Medicaid, maybe you do want to sign all those powers. So it's really a case-by-case basis.
Or what we could call a double-edged sword.
Correct.
It all just goes back to, Bill, knowing the importance of receiving the right type of legal advice, the same as trying to get the right type of medical advice.
Right.
So we're almost out of time, but I hope our viewers have learned enough in listening to us today that if they have more questions, they could call you. What's the phone number to reach you? We got time.
Okay, 321-253-1667.
253-1667.
That's here in
I
Brevard
remember.
County.
Who will you get? Sherry?
They will get Sherry, and
Okay.
she'll direct them to the right people.
Okay, thank you. We're out of time, but thank you, Bill,
Okay.
for doing the show today.
Thank you.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.